Hi, thanks, Andy, and thanks, Dennis, and hello, everyone. I'm Mitch Stoltz. I'm a senior staff attorney at the Electronic Frontier Foundation up in San Francisco. How many folks here are familiar with EFF? Quite a few. That's good. That's good to hear. It's a nonprofit digital civil liberties organization founded in 1990, donor supported. About 35,000 active donors and just about 100 employees. And coming up on our 30th anniversary. So Dennis had asked me here to talk about, in particular, the Oracle versus Google case, and a little bit about the history of it, why it's probably the biggest case to come along dealing with the law of software in quite a long time. So both what's happened with it and what some of the policy questions raised are, and it's relevant now. The case has actually been going on since 2012. It is an 8-year-old case and not done yet, but it has finally reached the Supreme Court, which is going to hear it sometime this spring, and could once again upend how we think of copyright in software, particularly copyright in software interfaces, which is what the case is about. So I'm going to talk about that a little bit, talk about some of the questions it raises, maybe take your questions and get into a bit of discussion about how we should think of copyright in software and legal protection for software generally. And then if folks would like to talk about some of the other issues that EFF is working on, I'm happy to do that too, particularly around software, the freedom to innovate, laws about computer hacking, and so on, or other cases that we're working on that folks have heard about and want to have a discussion about. Happy to engage in that. But starting with Oracle versus Google, because that is a big one. EFF has participated with friend of the court briefs at every level of this case, so it's been a consuming issue for us as well. What I was starting to write up here was the names of Java code packages, and those were at the heart of the Oracle case. I'll give a little bit of the history. Oracle acquired Java along with Sun. Java, at least at one point, a very popular programming language. And when Google was first developing Android, it ended up copying 37 sets of class and method definitions from Java, from the Java API, that were ultimately incorporated into Android. They're not compatible. Android is not Java compatible, but they were building on the knowledge and investment that developers already had in how to write Java programs to make it easier to write Android apps early on. Now, the way Sun and then Oracle had Java licensed was a good portion of it was available under the GPL, under the free software license. Google, for their own reasons, didn't want to deal with GPL code, so they ended up copying these without permission, not the code, not the implementation, just the class and method definitions. So the example that kept coming up in the case was if you want to compare two numbers, use java.lang.math.max, which will tell you the larger of two numbers to that function. Nothing about how that function was implemented, nothing about how it worked. Google did that themselves. They did it again. Just the bare fact of these are the words you use to invoke that function, the words that Java programmers were already used to using to invoke that function. That was one example, is that there were 37 of these packages. There were various figures given for how many lines. It was somewhere between 7,000 and 11,000 lines, but it was not implementation. It was definitions of classes and methods. Nonetheless, Oracle sued Google in 2012, claiming patent infringement and copyright infringement, and that was here in federal court here in San Francisco, and it went to a jury trial, and that jury threw out the patent claims. They said there was no patent infringement, but they said there was copyright infringement. But then the judge, this is Judge Alsop, a federal judge here in San Francisco, who had actually taught himself to code for the purpose of understanding this case better, an unusual step for a federal judge. He ruled that there could not be copyright infringement of these Java classes and methods, the piece of the Java API, because these just weren't subject to copyright. This was not the same thing as copying all of Java. It wasn't copying the implementation of Java. It wasn't copying any of the executable code or source code or object code that Java developers had built. It was just the definition of the interface that programmers could use. He said that wasn't something that was subject to copyright at all. Oracle appealed, and for this is more on the LawGeek side of thing, but I'll took an interesting path because they had originally been patent claims in the case, and there is a special federal court of appeals that handles patent claims. It's called the Court of Appeals for the Federal Circuit, and they come again. That's patent cases from all over the country. The patent claims in this case had already been dismissed, but because they were in there in the first place, the case went to the Federal Circuit. And the Federal Circuit reversed the trial judge and said, actually, yes, APIs are subject to copyright. APIs are computer programs. Legally, there is no difference. And if you copy an API, that's a significant piece of a computer program, and that's something that you need to get permission for, whether that means payment or through using an existing open source license that it's licensed under, or some other means. You had to get permission to use those, and you didn't. That's copyright infringement. But they sent it back to the trial court and to another jury on the question of fair use. How many folks have heard the phrase fair use regarding copyright? Quite a few of you. Fair use is a really important exception to copyright, but it's a kind of an open-ended one in which the judge and sometimes the jury ends up doing a balancing test of various factors. What the use was for, what sort of copyrighted work we're talking about, how much was used, and whether it's going to cause impact on the actual sales or markets for the original. And even though it's often really difficult to say beforehand the way that a fair use claim is going to go, it's really important that it's there, because fair use is what allows a lot of experimentation and creativity and things that have ended up creating really great art and really great science and really great engineering without asking permission first. Permission that probably wouldn't have been given, especially if you had to approach a company like Oracle that would rather just have that innovation happen in-house or be paid for it. Second trial. We're now in 2015. Quite an interesting trial, went on for several weeks, was a battle of the metaphors. An API is like the chapter and section headings of a book. No, an API is a file cabinet without the files. There were more, and they kind of went on for weeks. Right, of course an API is all and none of those, but to a lay jury, it often ends up a battle of the metaphors. Nonetheless, the jury in that case decided that Google's use was fair use. That went back up to the Federal Circuit on Oracle's second appeal. The Federal Circuit, again, upended really the expectations of most of the software world, overruled the jury, threw out the jury decision, and said, no, this is not fair use. Once again, this is copyright infringement. I didn't emphasize this before, but both of these decisions, that was 2014 and 2018, kind of feel like a bomb on the software industry, because API sharing and API re-implementation happens all the time. A lot of the most really sort of foundational parts of the computing world were sort of the result of re-implementing other interfaces, whether it was the various versions of the early Unix interfaces, which became the POSIX standard, which became, in all of its forms, re-implementations of with variations over time of APIs. There are lots of other examples. This sort of reuse happened all the time, and people didn't ask permission for it, and they never really believed that they needed to. And what these two decisions said was, re-implementing an API is something that you need permission from the original authors from. And if you don't get it, you're subject to pretty significant damages, copyright damages. In this case, we potentially run into the billions. Even in a small case, it's pretty easy to get them up into the billions, because they don't actually have to be based on harm. Copyright law allows for something called statutory damages, which is sort of litigation Russian roulette. It ends up being anywhere from $200 to $150,000 per copyrighted work, without a whole lot of guidelines as to how those get decided on. If you have a number of works, it can easily mean bankruptcy, especially for a small firm or an individual doing this sort of experimentation or trying to build something new.
Yeah, I don't know if you want to hold up questions or not. Yeah, I'm with a small software company. We're just abject terror of these decisions. But as you were going through the procedural steps at the beginning, you should clarify something I may have misunderstood. I thought Google fairly early on stipulated that the APIs were copyrightable.
The question was, did Google stipulate early on that the APIs were copyrightable? They may have made some statements early on, but it didn't affect the progress of the case. The case was two issues. First, are APIs something that you can copyright? And then, assuming they were, was it fair use to use an API without permission, re-implement an API without permission to build something new? Yeah.
So, I'm not a lawyer and I don't understand law, but I have under the impression that precedent is important. So, the first precedent that I'm aware of was the creation of the PC BIOS. Was that precedent considered in any of these proceedings?
The question was the creation of the PC BIOS considered a valid precedent in these cases? For lawyers, precedent generally means things that have gone to court. Was there a case on that?
So there were several attempts to replicate the PC BIOS when MS-DOS came out, and they were all declared illegal, and those companies were forced to cease and desist. The solution was a Cleanroom.
Mm-hmm.
The legal decision was that if you went into a room and you had no knowledge of what had been done by anybody who had legal right to that existing code, and you created it from scratch, which meant and it worked, which meant you had to implement all the same interfaces. Now, at that time, they weren't called APIs, but they are APIs. So, and that was litigated, and the result was the creation of two companies which legally sold a PC BIOS chip that created the whole clone industry.
So, I'll repeat some of that for the folks online. If I could summarize, the gentleman said there was litigation over the PC BIOS, which resulted in a decision that said a clean room re-implementation of the PC BIOS was not copyright infringement. That was absolutely raised in all of these cases. It was raised as precedent, along with a number of others. Another couple of other foundational cases. A couple were from the early 1990s about video game emulators, companies that had re-implemented the interface for old console video game machines in order to play their games on a PC, or vice versa, simply re-implemented it to build games without the permission of the console manufacturer. And in both of those cases, the court said, that's okay, particularly because you're doing it to create something new and you're copying no more than the know-how. Again, today we'd call an API, the know-how for coding new games or a new platform for games to the existing interface. And the other one was about the menu tree on the old Lotus 123 spreadsheet and the macro language that people use to automate spreadsheet tasks in Lotus. The case was called Lotus versus Borland, and Borland had used Lotus's macro language in its own spreadsheet program. The court said that was okay too. And then the reasons were interesting. I'm going to get into this a little bit because it's at the heart of the Oracle case as well, and I think it's one of the fundamental questions here. Is interfaces, APIs, there are various descriptions, and it is a bit slippery, but something that but things that allow for interoperability between programs or allow for creating new programs are not really the same thing as an implementation, which is where the cases that you mentioned come in. Those clean room re-implementations of the PC BIOS were, I would say, comparable to what Google did in using the class and method definitions, but not the implementation. And probably under the Federal Circuit's decisions in the Oracle case, IBM would have kept control of the PC BIOS, and Microsoft would never have gotten off the ground, and we'd be living in a very different world.
Yeah, it seems like the distinction between the implementation and the control surface. Now, I was just wondering, did anybody in these cases ever ask the question, who owns SQL, the definition? Somebody in our lifetimes owns it. It's copyrighted if this case holds. Oracle depends on that. Their life, blood of income is dependent on whoever owns SQL.
Yeah, it's owned by a standards body.
Okay, so would enforce it.
Well, the standards body is open license. Free and notice.
The question was what about the ownership of SQL, being one of the crown jewels of Oracle. There others have implemented that. MySQL is.
Are standards bodies going to start not fair and openly licensing this stuff? What's going to happen?
The question is what's going to happen with standards bodies. It's a really good question, and I like to defer it because I wanted to kind of get into some of the questions raised by the Oracle versus Google case, and then that one I think is kind of an upshot of all of these. Is what does this mean for technical standards in software, or even in hardware for that matter? Let me go a little bit deeper and say, if it could take you into a little bit of law geekery, right? Copyright applies to software, but it's never been a really good fit. Strictly speaking, when you're talking about copyright, software is considered a literary work, which I know I got some chuckles from that. It's a little weird, right? So copying an entire software program, source code or object code, in many circumstances without various exceptions and justifications, right? It's pretty easy to see that that's copyright infringement in many cases, and under those circumstances, it makes sense to apply copyright to software. You also have patents. Now, you didn't originally. It was copyright in software happened earlier than patents in software. But even early on, and even with the addition of patents, there was the recognition in the courts and certainly in the software industry that some kinds of copying were okay, or it had to be okay, or everything would grind to a halt. Copyright doesn't cover ideas. It raises this somewhat metaphysical distinction between ideas. On one hand, you have ideas, systems, methods, processes, procedures. That's on one hand. On the other hand, you have creative expression. And creative expression, that's the world the copyright comes from. So the creativity that goes into music or literature or photography or visual art or so on. But what does that mean in software? Where do we draw this line between the creativity? I think we'd all agree that software engineering can be creative. But where's the line between what's creative and what is an idea, process, system, method, procedure? And why draw that line? One of the reasons is reuse, the holy grail of software engineering. Reuse maybe not necessarily requiring permission. What can even be owned? Some of these things then crash into patents. So you think a method or a process. Those are things that classically, and now with software as well, can be patented. You can patent a process for achieving a result, a method for making something. So copyright then excludes those things. And then some things just aren't subject to property at all. So copyright leaves out things that either are best handled by patents or that just shouldn't be owned at all. And the question in the software world, and the questions raised by this case are, what is that? What should be owned and what shouldn't? And what makes sense? So a couple of the issues that came up in this case. Again, this is being argued to the Supreme Court right now. They turned it down the first go around. They've accepted it the second time after 8 years of this case. That means at least 4 of the 9 justices saw something in it that they wanted to review. It doesn't really say anything about how they're going to review it. And it's pretty hard to predict. But some of the things that have come up is, are APIs the same thing as computer programs? Or are APIs such a significant piece of a computer program that they ought to get the same protection? How much should the ability to reuse, to have specifically the ability to re-implement an API, how much should that matter? To be able to do that without permission. And then the other one is how to account for network effects. Copyright is based on the idea that people should be compensated for their creativity. You've created some original work of literature or visual art or music or sculpture or choreography, and you've shared that with the world. You should be compensated for that. But when we're talking about APIs, the value often lies not in, at some point anyway, not in the creativity that went into making them, or even sometimes the technical merit, but just how often they're used. this ties into the standards question, so I want to get to that. What Google argued in this case, and EFF did as well, that it wasn't so much Sun and Oracle's efforts that made the Java API valuable. It was the computing world's investment in learning how to code to that API. And that wasn't so much because of its merit as more as its ubiquity. Network effects. The more people using it, the more valuable it is, regardless of its technical merit or its creativity. And if that's the case, then maybe it isn't something that should be owned. That's the argument raised there. Now, Oracle has raised good arguments as well, and has succeeded twice before the Federal Circuit on this case. Also, going back to your earlier question about precedent, the Federal Circuit, which again mostly handles patent cases, has an unfortunate tendency to twist precedent. They don't ignore it, but they read into it what others don't. Especially interesting in this copyright case because it isn't their regular area. They don't usually get copyright cases. It's sort of an unusual set of circumstances that led to them hearing a copyright case. And because of that, they were supposed to apply the law created by the other federal appeals courts like the Ninth Circuit, which is here in California. And the Ninth Circuit had already said that copyright favors reuse and re-implementation, particularly to create something new rather than just to reproduce something already made. But they read that a little differently, and they said, "No, we don't see it that way, because there's not legally a distinction between an API and a program." It's interesting they used this phrase that Oracle was using as they called this declaring code. I don't think that's too common a phrase in the industry. You'd say declarations maybe, or you'd say header files. But they called it declaring code as a way of saying that there's not a difference between declarations and implementation. It's all code. And if you use someone else's code, you need permission. That's what the Federal Circuit said, and then so let's put the weight on the other side of the scale here, because there can be technical merit to an API. There can be some APIs are more useful than others. You could even say Java was successful because of its ingenuity. And that itself, deserves a reward. And reusing that ingenuity without permission is wrong. There's some merit to that as well. But that's where we are going into the Supreme Court case. Which I had a question here.
I'm trying to clarify in my mind exactly how far Oracle's claims go. And part of this is based on some experience I had a long time ago when I ported Unix onto the Craze out of Livermore, and we put a Fortran bottom end in the bottom of Unix to talk to their underlying operating system. I look at the API as a control surface. There's a service side and a client side. I assume Oracle is claiming all the way up on the service side, right up to that control interface. But what if I'm on the client side? I go out to the bookstore, I buy myself a book on Java, and I write binary code that marshals the arguments, sticks them on the stack. There's not a whiff of Java or any predecessor involved on that side of the code. Would that be covered? Well, I'm not even using java.lang, whatever. I'm actually marshaling the arguments onto a stack.
So it's a great question. I mean, it sounds like you're describing a very strict Cleanroom implementation of an API. So it's possible we don't know yet. Law works iteratively, and that's not that wasn't the facts of this case. Now we have the earlier cases. We do have the PC BIOS and so on that said, if you really come in with zero knowledge, if you completely using experimentation write a completely original piece of software, perhaps that happens to be binary compatible with an existing service, and you haven't copied anything. It's an easier case, actually. That is likely not copyright infringement, even in this, even in Oracle's world, even in the Federal Circuit's world. That's pretty hard, and that's not something that a lot of folks actually do, especially if you're talking about something on the scale of the Java API or a lot of things that are happening out there today. It's not impossible, but it's pretty hard.
I could write machine level, whatever, C language, whatever language code, just not Java, that marshals the arguments, hands them over the stack, does whatever interrupt it is to get them across the border to the job to Oracle's code, which they absolutely own, and in all respects, except that I'm going to present my own back API, which I'm going to call foo.lang.quack, and which Java code can use. And I'm just going to have my own variant Java API, which I'm going to invent a brand new one. And I've inserted this layer in the middle that is not at all dependent. Can I do that?
Probably yes. A basic fact of copyright. And this, again, is coming from the world of literature and film and photography and so on, is if you never saw the original, you can't have copied it. And if you really can implement an interface, never having seen the server code.
Well, I bought a book that just publishes. I read it. I understood it. I'm not copying it. I'm just executing it.
Oh, but see, right? If you bought you bought the book and read it, that's under copyright. You've had access to it, and book of recipes. But the question in this case, and the question that comes up is, did you take too much? That's where the line drawing occurs, and it doesn't map cleanly to a lot of software engineers' understandings of the difference between interface and implementation. It should. There's a way to do that, and hopefully that's what we're moving towards. But if you've read that book, then you are not in the clear anymore.
But I am free to use recipes in a cookbook.
Right. So he said he's free to use recipes in a cookbook. That gets into the question of when have you taken too much. Under copyright, you are free to use recipes in a cookbook, but not to copy too much of the creativity that went into the words of the recipe. The problem with software is that software is text, in a sense, especially if we're talking about source code. So, yeah.
So I'd like to start at the beginning.
Sure.
So how do you affect a copyright on software? In the early days of the PC, there were people who said you couldn't copyright software. So what they did was they wrote it down in the form of a book and self-published, create a publishing company, published the book, and therefore the code was transmitted as a book, which was copyrighted, and that copyright was recognized and accepted. And then if you actually sat down and read the copy and typed it in, then you had to buy a license, and it was very clear. How today is a piece of software copyrighted?
The question was, how is software copyrighted today? The last complete overhaul of our copyright law was passed in 1976, became law in 1978, and it had a few changes relating to software copyright in the early 1980s. And since then, copyright is automatic. This is, I think a lot of folks don't realize this, but if you scribble a note on a napkin, it has copyright. You take a photograph, it has copyright. And if you write code, all but the most simple bits of implementation, at least, have copyright as soon as you set them down. You don't have to publish them in a book, and you don't have to register them with any government agency. You get certain benefits for doing so. You actually have to register it before you file a lawsuit. But copyright is automatic from as soon as you set it down.
When you register, do you have to demonstrate the creation?
Question was, when you register, do you have to demonstrate the creation date? You have to give them a creation date. You don't have to give them evidence in the form of a published book.
No, but what kind of evidence? So somebody's going to challenge you. Say, okay, yeah, well, that's great, you created it, but I created it first.
The question is how are priority challenges resolved? Any kind of evidence comes in on that. It's no longer a matter of formality, like I made it to the Copyright Office first, or I published a book first. Those sorts of questions in copyright land, as opposed to patent, although patent is moving that direction too, but they get resolved in court, and the court will look at whatever evidence you can bring in of when you first set it down on paper. And that actually is the date that or on a hard drive, and that's actually the date that matters.
So in this case, is there any dispute about what is copyrighted and when it was copyrighted?
The question is this case, and there any dispute over what was copyrighted and when? Not really. Both sides and nearly everyone involved acknowledges that Sun wrote Java and that Oracle owns the copyrights in Java. The question is a narrower one of, is the API part of something that can be copyrighted, or does it fall outside of that? That's our question over here.
This seems reminiscent of Apple's defense of the Macintosh software, that if you could build your own hardware, it wasn't difficult. You could even write an operating system, but you couldn't provide the API that would let Apple software run on your hardware. And they successfully defended that from all takers, right?
The question was how did this compare to Apple's legal campaign against Mac clones, basically, right?
I heard a rumor that they had some string in some API that you could call it and return that string. And this was maybe to hedge their bets, and they considered that string a copyright string. It wasn't particularly clever, but because it was a textual thing, that would be obvious that they achieved it.
So the question was whether there may have been some text string in the Mac OS or the previous versions of that would be creative and thus copyrighted. Yeah, a lot of folks over the years have tried to sort of put little copyright traps into things that wouldn't otherwise be copyrighted. This came up in luxury watches, that they would etch a copyrighted design onto the back of them and try to use that copyright claim to prevent importation of the gray market importation of those watches. The Supreme Court ultimately said that was okay. The importation was okay. That's not what copyright is for. Apple more broadly, I don't think the precise question about re-implementing an API ever came up, because as far as I know, all of those Mac clones, this is mostly, I think, in the 90s was in the era was this happened. They were copying code. They were copying implementation from Apple. Going back to this question about difficulty, I don't know that anyone successfully achieved a perfect clean room re-implementation of an Apple operating system.
That question, it wasn't the question whether you could run Mac OS on hardware that wasn't Mac
Yeah, maybe that was it.
Yeah, because they clearly own the operating system. So can you, the clone business requires an operating system and a manufacturer, and a hardware manufacturer being separate. If you're a hardware manufacturer and they won't license you to put the operating system on it, you're hosed. So all they have to do is just don't license it to run on non-Apple hardware.
That's right. That was what you're referring to. It's a licensing issue. You said that Apple could simply refuse to license its software to run on non-Apple hardware. It's another key question in software copyright, honestly, and we could spend another hour on that. But this notion that you always need a license, right? Because even loading a program into RAM is making a copy of it. Under what's so that gets into so you need the copyright holder's permission just to do that. That's raises another set of issues.
If the permissions to have the program don't include loading it and running it, I'm not going to buy it.
Well, with EFI and secure boot, the permissions are kind of hidden there.
Yeah, well, that's a different problem.
My question I was going to ask is, much discussion has gone into APIs that are not based on inside a single processor or memory system, but like web interfaces, like Google Maps interface, RESTful interfaces over the net.
The question was, has there been thought put into things like web interfaces, interfaces that are not occurring on a single processor, but that are occurring over networks? A lot of folks are worried about that. The way that these Federal Circuit decisions were written absolutely implicates that. It wasn't the facts of this case, but that seems to be very much at risk now. And I think the legal departments of a lot of software companies have been kind of a bit frantic for the past few years about what this is going to mean. There have been follow-on lawsuits, by the way. Not a flood of them, but there have definitely been follow-on lawsuits by other folks claiming copyright in APIs and claiming the right to stop re-implementations of their APIs. So this is happening elsewhere. There's not a clean way to distinguish APIs that are running that are an interface between software running on a single processor and an interface between programs running across a network. There's not a clean way to distinguish those in the law as we have it right now.
So another similar question, distinction. We're talking about APIs that are publicly exposed so far. There's a whole class of APIs that are not publicly exposed, that are companies developed with internal use between modules created internally to the company. Is there a way to protect those that's differentiated from the public ones?
The question is there a way to protect internal APIs that are not exposed to the public? Those can be trade secrets, and trade secret is a different beast than copyright. The classic example of a trade secret is the formula for Coca-Cola. If that had been patented, it would have become public domain sometime in the 19th century, but because they've managed to keep it a secret until now, they have legal tools at their disposal to protect that secret. The same could be true of a non-public API. The exception when you're talking about trade secrets is that reverse engineering through means that don't involve any sort of corporate espionage. Getting back to Cleanroom, a Cleanroom reverse engineering of, you can look at the binary, you can look at the chip, you can strip the chip, so on and so forth, is all okay. That's not considered improper means when we're in trade secret land. And some folks try to, that's a problem for some folks and not for others. You also have patents. And patents can in some circumstances, cover APIs. No. It's I appreciate the dialogue.
Somebody behind me?
Yeah.
Patents usually have like a 17 or 20-year lifetime. What if you're caring about continuation in part, which allows you to sort of extend things with a minor change? How does that work, and is that applicable?
The question was talking about the concept of extending legal rights over software with a minor change. That does happen in patent land. Patents do last 20 years. Copyrights in the corporate context last 95 years. So no piece of software that was written for a digital computer has yet expired. Some of them have been given to the public domain, but the copyrights, no copyrights have actually expired yet. The copyrights, the last copyrights to expire, just this past New Year's, were from 1924. But to get at your question, we are starting to see that with things like literature, and it does happen in copyright land too. So the court said, for example, there was a copyright infringement case about writing new Sherlock Holmes stories and whether those violated the copyrights on the original Arthur Conan Doyle books. And the court said, well, since the first of those books are now out of copyright, but the latter ones are not, you can write new Sherlock Holmes stories. You just can't use any aspects of the character or plots that come from the latest books. And that absolutely is used, or probably will be used in software land too. And of course, we think about embrace and extend, or we think about the evolution of a standard or an API. You can certainly, the entities in control of it, whether that's a standards body or a single company or a couple of companies, can change it a little bit over time to make other versions incompatible or at least less functional. And in doing so, yeah, they have a new copyright. And the copyright in those changes will last longer. So the problem you're describing is very real. It's just copyright terms are already so long that we haven't reached it yet.
I'm thinking that when software first started becoming a little bit popular, they were patenting a lot of it. And patents, you work for a company and you learn all that stuff is going to be protected. But things that are patents that run out, tab key to go to the next field was patented. Big Indian, Little Indian to swap plates was patented. Shift, rotate was all patented. And you couldn't do any of those things if they're patented if you got caught. But if you didn't get caught, there was no problem. Now it's expired, so you can do it, I guess.
That's right. The question was about patents and a lot of pretty foundational elements of user interfaces and so on were patented at one point, and those patents have now expired. Yeah, patent plus 20 years. When they're expired, the world can do them. That's the bargain. The bargain is 20 years of exclusivity to make money off of, and then your invention belongs to the world. The other question then is, should those things have been patented in the first place? We could spend many hours on that, and it's another set of fascinating conversations about what should be patented. But things should probably mostly stay in copyright land today.
Because of prior use someplace else. But
Often, yes, yes. Patents can be challenged if the invention wasn't in fact new. If someone else had done it earlier, and you can show that.
And a trade secret. For example, you could patent Gore-Tex, because Gore-Tex is still a trade secret. It's not that.
Yeah, that's right. Yeah, I mentioned Gore-Tex as another example of a trade secret.
But if you Cleanroom it, or not Cleanroom, but reverse engineer, presumably you could patent.
That's right. You could probably patent it as well. You can patent an original material. Yeah. Yeah. Two more questions, and then I think I'll move on to a related topic.
So, this is just hopefully the last question. If a legal copyright owner puts something in the public domain, can they remove it from the public domain and claim private ownership having put it in the public domain?
Really good question. The question was if a copyright owner puts their work in the public domain, can they snatch it back out of the public domain? Surprisingly, the law is not totally clear on that, especially outside the US. Probably, once you've put something in the public domain, the world is entitled to rely on that. That you've said that. So I put version 1 of my software dedicated to the public domain, and I say that publicly. Presumably, anyone is free to copy version 1 of my software, edit it, build upon it, release new versions on their own. Little less clear in other countries where copyright is more considered what's called a moral right, something that you can't give away. And it comes up in one interesting context in US law, and it's variously called terminations or reversions. This was a clause meant to protect artists who sold their copyrights to publishers or others when they were young and poor, and later when they become world famous and successful, it's a mechanism that allows them to reclaim their copyrights from whoever they sold them to earlier. And it can happen in a 5-year window. I believe it's 30 to 35 years after first publication. This was invented in the 1976 law, took effect in 1978, so they were actually only just into the 30-year window, a few years into the 30-year window for stuff that was created in the 70s, and some musicians have been using that to reclaim their copyrights from record labels, for example. Some original comic book artists and their heirs have used it to reclaim some copyrights from publishers. I'm not aware of it happening yet in software because, again, nobody's really suing over 30-year-old copyrights that often, but it's going to come up, and it's going to come up eventually. And then we have this interesting question of whether if something has been put into the public domain by a later owner, whether the original owner can snatch it back. It hasn't come up yet. It's going to be really interesting when it does. Yeah.
Case where someone stole an article that was on my website, copyrighted, and she put it on her site and said it was in the public domain, going in copy it. So I mean, I was thinking, my word, this is audacious. Not only do you steal a thing in the first place, but then you say it's free of all. I did get her to take it down, but it was it was on a Nazi site, so it was it was kind of weird.
Well,
They had to try some revenge stuff.
Like any lawyer would tell you, that's not kosher. The question was taking an article and took her article, put it on another website, and said that it was dedicated to the public domain. It's not. Just saying the words doesn't make it so if you didn't have the right to do that in the first place. Yeah.
A particular company who was a participant in a particular open source group donated code to the open source group. And one of the other members of the open source group had said, hey, that's my code. And I didn't give it to you. You didn't buy it from me. You stole it from me. And you don't have the right to put it in the open source group.
Mm-hmm.
And because both companies were in the open source group, and I can tell you later who they were, there was enough embarrassment that it was taken care of.
Oh, that's no bell.
No.
So the question was somebody contributing code to an open source project that they didn't actually have the right to contribute because someone else owned the copyright and didn't want it contributed. These things happen, and it can be tricky for others to be certain that all the right permissions were granted. For the most part, in the open source free software worlds, there have been a few court cases, but those have really largely kind of been handled by sort of community norms and pressure and quiet negotiations. It's rarely gone to court, and that's more cultural phenomenon than anything. But it also means we don't have sort of official decisions about what the law is in those circumstances. Last question.
I've been working with self-driving cars, things like that. One of the big issues is Bubba the neighborhood mechanic who replaces, a Ford rear distance sensor with, one stolen off a broken bullet. There's been the issue of how do you prevent false devices or bad pieces being put in there? And one of the techniques is connectors. Every connector is a different shape. This seems to be totally applicable to copywriting connectors. It's also similar to printer cartridge issues. It's also similar, right behind you is a crash bar on the door. That's an API. Imagine somebody who claims to own that thing. Every time you walk up to the crash door, you have to insert a quarter to get out. Where does this stop?
I'm really glad you asked that, because it segues into the other subject I wanted to spend the last 15 minutes on. We have till quarter out, right? Is that and the question was about legal protection for hardware interfaces, but also for issues like car repair or repair of physical devices. Copyright generally doesn't apply to the shape of physical objects, except in some rare circumstances, and it doesn't apply to functional objects like a crash bar on the door was your example, or the physical shape of a cable connector to car parts. Those can sometimes be covered by patent. It is the
software API. Doesn't the use merge into the functionality?
You mentioned the merger doctrine. I didn't use the technical term, but that is right at the heart of the Oracle case. Is does the even assuming that there is creativity in this case an API, does that creativity merge with the functionality? Again, we're really kind of getting into metaphysics, but that's why it's sort of a fun area of law, because we do get these metaphysical questions. Does the creativity merge with the functionality? The Federal Circuit said no. They said as long as there are multiple ways to do it, the creativity doesn't merge with the functionality. It's a very narrow interpretation of that idea. The one the Federal Circuit used was they didn't have to call it java.lang.math.max. They could have called it arithmetic.larger, and it would have had the same function. And because there were multiple ways they could have done it, it's creative, and thus they can prevent copying. That leaves out the entire discussion of the value of interoperability, the value of reuse, and who's creating the value. Was it the original creator, or was it really the people who use it and thus sort of turn it into something they've all invested in? That narrow definition of merger leaves that out, and as you pointed out, that could come up in a physical interface too. But typically that's going to be patent and not copyright. I wanted us to segue into talking about another law that vexes software developers and also repair people. So you'd mentioned car repair and printer cartridges and so on, and that's it's known as the Anti-Circumvention Law, or Section 1201 of the Digital Millennium Copyright Act. You'll often hear the phrase technical protection measure, or TPM, used in this context. Well, this was an add-on, a separate body of legal thought that was created in the 1990s. So this was law in the U.S. in 1998, in Europe shortly after that, and in many developed countries, but not, after that, but not all. There are at least a number of very technically sophisticated countries that don't have this. But the idea is if you have any sort of copyrighted work, whether that's sort of traditional creative work like music, video, literature, and so on, or software, if you put some sort of effective access control on it that prevents people from accessing it or copying it, there's sort of two strains there. We're talking about an access control or a copy control, but some kind of technical measure that makes it difficult to access or copy something. Some legal protection attaches to that. And it becomes illegal to break that protection because someone might then copy the creative work or the software illegally. But it's separately illegal just to break the protection. So this was, again, a concept created 22 years ago in U.S. law. It's had all kind of weird spillover effects, or maybe not so weird, in terms as to whether they were intended. The paradigm in the 90s was the encryption on DVDs, or various encryption schemes that had been proposed for digital music back then, none of which had any success in the market. DVDs did. And the notion was we'll encrypt DVDs. It wasn't a complex encryption. It was fairly simple. It was I forget exactly how long the code was, but I remember it fit on a T-shirt. It was just a few lines of code could decrypt a DVD. But because they'd applied encryption, breaking that encryption without the permission of the rights holder or of the technology vendor was separately illegal. And they put in some exceptions that ultimately weren't all that useful to people. And then there is a process that occurs at the U.S. Copyright Office every 3 years where people can come in and ask for exceptions. The interesting, and I say that word with a grain of irony because really it's pretty troublesome, but many of the problems have come up. Many of them have come up in traditional media because this law interferes with creative reuse of video, for example, and music. But in the software world, what it's meant is you slap some sort of access control on your software or hardware, and you gain this very powerful legal tool that prevents interoperability. Also sometimes prevents repair, prevents security research. There are exceptions for repair and security research. The ones that were built into the law have ended up being so narrow and subjective that they're almost never used. People just haven't been able to trust that they're actually going to be shielded from lawsuits by trying to rely on these. It's an absolutely big issue in voting machines. The various vendors of electronic voting machines have made DMCA 1201 claims to try to actually stop independent security research. In recent years, in the 3-year exemption process, we've managed to convince the U.S. Copyright Office to grant somewhat broader exceptions for security research and for repair, not for tinkering or experimentation more generally, even where there's no underlying copyright infringement. They've always said that it's a separate thing, just breaking the encryption, or it is always encryption, but it often is. It could be simply bypassing a password check in some cases. The level of sophistication doesn't have to be high to trigger the application of this law. But it's been a real problem for computer security and for repair. It's been claimed on the interface between printer cartridges and printers. Actually, that was a rare case when it wasn't successful. It's been claimed the radio protocol for a universal garage door opener, whatever the radio handshake is between the garage door remote and the opener. It has often been claimed against security researchers, including one who was famously arrested after giving a talk. This is a while back. And the other really significant problem is that these exceptions that we get every 3 years, they only apply to actually doing the circumvention, but they don't apply to making tools. The law basically assumes that everybody can roll their own decryption, their own tools, because creating or distributing the tools to do it is often illegal, even if doing the circumventing the access control is not.
Did you ever meet Bill Karn?
I did not.
The DCSS code, printed it at an OCR in a book, and he said, I have a First Amendment right to publish this.
Mm-hmm. Talking about printing the DCSS, the DVD decryption code in a book. My colleague at EFF, Seth Schoen, wrote a version of the DCSS algorithm as a haiku, as a proof of concept that code is expressive and should bear First Amendment protection. EFF is engaged in a legal challenge to the DMCA in its entirety based on the First Amendment. Our clients in that case are a security researcher and an entrepreneur. And their claim is that this anti-circumvention law, particularly the trafficking provision, that's what it's called, but the creation and distribution of decryption tools and so on. The clause making that illegal is an unacceptable restraint on speech. And even the 3-year exemption process at the Copyright Office is an impermissible speech licensing regime. And we cleared the first hurdle in that case. The court said that we have potentially stated a violation of the First Amendment, and that we're entitled to proceed and to prove it. So, well, we'll see how that goes. But there are very significant free speech implications for this, going back to the case in the 90s that said code is speech, and certainly teaching others how to code something is speech.
So how does that relate to the API dispute?
The question is, how does it relate to the API dispute? So not directly. This was not raised in the Oracle case. The way it relates is this law, Section 1201, is another method that is sometimes used to lock down APIs in the broad sense. It's a lockdown compatibility. So to prevent the use of generic or remanufactured ink cartridges in a printer by putting an access control on the API between the cartridge and the printer. So it's an additional layer of legal hurdles that didn't even come up in the Oracle case, but it comes up a lot in the automotive context because the software in vehicles very often is subject to some sort of access control. It's made difficult to dump the code from a car, and in some circumstances, trying to get at the even the interfaces to the CAN bus in a vehicle might potentially involve circumventing an access control. And that's used, of course, to enforce restrictions on who can repair cars. It's used to drive people to expensive factory-authorized repair and away from independent repair. It's used to conceal security flaws in some cases, yeah.
But let's say you remove that law, then you still have an API that you're connecting to. So do you end up then having to pay a license fee to connect to the CAN interface?
The question was, even without Section 1201, you're still faced with various APIs that you have to interface with to connect devices to a vehicle, and would that then require a license fee? That's going to depend on the outcome of the Oracle case. I mean, we come right back to these issues about whether it's legal to re-implement an interface without permission from copyright owner. We're just about at time. I can take a couple more questions, I guess, but otherwise I'll stick around for a little while afterwards too.
The corner that I heard of on the repair issue was farmers and tractors.
John Deere.
You mentioned farmers and tractors. Absolutely. John Deere has been particularly vocal and litigious about limiting access to their tractors. It made a splash. This was 2 rulemaking cycles ago, so it was 2015 when they made the claim in public that they were worried about people pirating music on their $300,000 tractor. Relatedly, and I've just read a report that old John Deere tractors are in such high demand that they're actually more expensive in some cases than new ones, and that's because they can be independently repaired, and the new ones can't. So this has very real economic implications.
That goes back to the original question. Why is Larry suing Google? I think that he would want people to write. He would want the world to be full of Java programmers so they can.
Because we can't.
Yeah, well, that's.
Well, this is why is Oracle suing Google in the first place? There is a lot of money at stake. This is, if Oracle is successful, it's a multi-billion-dollar judgment, quite possibly, and I have to imagine he's weighed that against the free marketing, if you will, or the benefit that comes from having even more people writing Java by virtue of writing Android apps and learning that API and having that API become more of a more ubiquitous and become a standard and probably keep Java alive for another decade. These are considerations that any software company can and probably should have. It's valuable to be the originator of a ubiquitous API, even if you can't control every use of it. Ultimately, probably more valuable. But that's where we are, and not everyone agrees.
Yeah, there's the phrase "rust never sleeps." I occasionally go to hackers conferences, and I was amazed at how these people go up to something that's like a black box and they explore it. How did these people discover that voltage over voltages to Intel chips would blow out the random number generated in certain predictable ways? Is Oracle claiming enough of the interface to even block that kind of exploration of a device?
Let me see if I understand. The question is Oracle claiming how far are they claiming? Their claim revolves around Google using these 27 header files.
Program that tries to do populations and stuff with no concept of the Java API, and just look at what happens and figures out. This is the way biology works.
Again, going back to what we said, if you actually never saw the original code, or even read a description of it, if you really are doing a clean room, if all you have is a black box or a chip or something, and you are simply throwing random input at it, and you find input that allows you to interface meaningfully with it, there is no copyright problem. There could still be a patent problem, but there is no copyright problem. But from my point of view, from the lawyer's point of view, that rarely comes up.
But is that actually litigiously true, the statement that you just made?
Mm-hmm.
Has that been, is there enough case law, both in the U.S. and internationally, to rely on that?
I would say yes. The question was, is there case law that says completely clean re-implementation is not copyright infringement? There is. And there are cases from outside the software world that say if you come up with a story about, a boy who discovers he's a wizard and goes off to magical school, but you've never actually read Harry Potter, you're fine. I think we're at time, but thank you all, and I will stick around.